Hello, my name is Professor Shiladitya Rakshit. I am recording this module on behalf of Professor Nitin Gombar, OP Jindal Global University. Dimensions of right to environment, the Indian perspective. Introduction. The linkages between human rights and environmental protection have long been recognized and have been subjected to extensive debate. It is generally accepted that from of human rights perspective, environmental protection often proves a necessary condition for the full realization and enjoyment of other human rights. At the same time, environment degradation can have serious negative impact on the enjoyment of various social, economic and cultural rights as well as civil and political rights. In a world of increasingly severe and widespread environmental degradation, new tools are needed to respond to environmental harm. Traditional international environmental law addresses the rights and obligations between nation states has little to offer individual harmed by environmental damages. As a result, the judiciary all over the world has developed various dimensions of right to environment for its better protection. This chapter discusses various facets of right to environment which have been established by Indian judiciary primarily, and also discusses some of the dynamic interpretations given to right to environment by different courts all over the world. Learning outcomes. To understand the dimensions of the right to environment, role of Indian judiciary, to understand the right to healthy, wholesome environment, to understand the right to pollution-free air, to understand the right to water, to understand the preservation of open spaces and parks, to understand the right against noise pollution. Dimensions of right to environment, role of Indian judiciary. Environmental rights are commonly understood to mean the reformation and expansion of existing human rights and duties in the context of environmental protection. This view falls between simple application of existing rights to the goal of environmental protection and recognition of a new full-fledged right to environment. The Economic, Social and Cultural Rights Committee has addressed the right to a healthy environment. In General of Comment 14 on the highest attainable standard of health, the committee established that the right to health embraces a wide range of socio-economic factors that promote conditions in which people can lead a healthy life and extends to the underlying determinants of health such as food and nutrition, housing, access to safe and potable water and adequate sanitation, safe and healthy working conditions and a healthy environment. It further elaborated that the right should be interpreted as an inclusive right extending not only to timely and appropriate health care but also to underlying determinants of health such as access to safe and potable water and adequate sanitation, adequate supply of safe food, nutrition and housing, healthy occupation and environmental conditions. Hence, it can be seen that right to environment or environmental rights includes various claims either linked with an existing human right or emerged as an independent right. Some of the most important dimensions of right to environment identified by Indian judiciary are as follows. Right to healthy, wholesome environment. Every human has a right to live in a clean and healthy environment. This is a general right which is inalienable. Many constitutions all over the world has guaranteed a healthy environment, and they also take appropriate measures to prevent any kind of environmental harm so as to maintain a healthy environment. They not only prevent any kind of environmental destruction but also aim to preserve the nature and its natural resources. In Colombia, the case of Antonio Mauricio Monroy Cespedes in 1993, the court observed that side by side with fundamental rights such as liberty, equality, and necessary conditions for people's life, there is a right to the environment. The right to a healthy environment cannot be separated from the right to life and health of human beings. In fact, factors deleterious to the environment cause irreparable harm to human beings. If this is so, we can state the right to the environment is a right fundamental to the existence of humanity. Right to healthy environment is an important attribute of right to live with human dignity. The right to live in a healthy environment as a part of Article 21 of the Constitution was first recognized in the case of rural litigation entitlement Kendra for a state popularly known as the Dehradun Quarrying case. The apex court, while deciding that certain limestone quarries in the Doon Valley should be closed down due to soil erosion, deforestation, and river silting, declared for the first time the right of people to live in a healthy environment with a minimal disturbance, ecological balance shall be safeguarded. It is to be noted here that though Supreme Court evolved a new right to environment, right of people to live in a healthy environment, it did not mention or discuss the source of the right. In M.C. Mehta versus the Union of India, the Supreme Court impliedly treated the right to live in pollution-free environment as a part of a fundamental right to life under Article 21 of the Constitution. The Supreme Court of India in Kshatriya Pradushan Mukti Sangharsh Samiti versus State of UP for the first time declared that the right to environment is contemplated in Article 21 of the Constitution of India. It was in the case of Subhash Kumar versus State of Bihar, the apex court explicitly recognized right to wholesome environment included in Article 21 of the Constitution, which it held right to live is a fundamental right under Article 21 of the Constitution and includes the right of enjoyment of pollution-free water and air for full enjoyment of life. If anything endangers or impairs that quality of the life, derogation of laws, a citizen has a right to have recourse to Article 32 for removing the pollution of water or air which may be detrimental to the quality of life. Thus, the Indian judiciary, through its dynamic interpretations, established a right to healthy, wholesome environment as a fundamental right. Right to pollution-free air. Air pollution has become a major problem in the world. It negatively affects human health, the environment, and the economy. It is basic knowledge that air pollution harms human health and the environment. Air pollution is a major risk factor for a number of health conditions including heart disease, respiratory infections, stroke, chronic obstructive pulmonary disease, and lung cancer. It also damages the environment. Toxic air pollutants cause harm to things such as crops, trees, wildlife, and all types of bodies of water. The same pollutants can also harm fish and other aquatic life. Thus, it can be seen that nothing is more basic to life as well as for quality environment than having pollution-free air. The right to pollution-free air can be traced to the Stockholm Declaration in 1972. The Declaration in principle provides that man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of a quality that permits of a life of dignity and well-being. And he bears a solemn responsibility to protect and improve the environment for present and future generations. It can be seen that every man is entitled to have a right to a quality environment, and which is a basic human right. It is also to be noted here that pollution-free air is a primary component of quality environment. The Supreme Court of India in M.C. Mehta versus Union of India and others stated that every citizen has a right to fresh air and live in a pollution-free environment. Again, in Charan Lal Sahu versus Union of India, the Apex Court reiterated that the right to life includes the right to pollution-free air. Subsequently, in Subhash Kumar versus State of Bihar, the Bihar High Court declared the right to the guaranteed by Article 21 includes the right to enjoyment of pollution-free air and water for full enjoyment of life. If anything endangers or impairs that quality of life in derogation of laws, a citizen has a right to have recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to the quality of life. Though this decision, the court recognizes the right to pollution-free air as a part of the fundamental right to life. Right to water. Water is the essence of life. In fact, without water, no life is possible. Human beings cannot live without water for more than a few days, as water plays a vital role in the physiological functions of human body. Water is also very essential for the day-to-day activities of human beings, such as for agriculture, industrial purposes, domestic purposes, maintaining hygiene, to cook food, and for a variety of social and cultural reasons. The right to water has a strong social and ethical dimension to it, as water is the most basic necessity of life. In fact, life originated in water, and without water there can be no life. The ethical basis of this right is rooted in the religious and cultural significance attached to the water in almost all civilizations and societies of the world. Such a basic amenity is naturally owed to the people, as only logical that the state has a duty to protect this right and to take steps to ensure it. The first express recognition of right to water at the international level was in the UN Water Conference in 1977, in which General Assembly recognized that the Mar del Plata Action Plan. The action plan declared that all peoples, whatever their stage of development and social economic condition, have the right to have access to drinking water in quantities and of a quality equal to their basic need. An analysis of the numerous judicial decisions reveals that the Indian judiciary has taken an active role in incorporating various facets of right to water in India. This approach of judiciary started by way of interpreting the word right to life under Article 21 and establishing right to water as an integral part of right to life. Subsequently, the courts have read Articles 48A and 51AG with Article 21 and emphasized that the state having an obligation to ensure wholesome environment. Thus, the right to water in India is also from the fundamental right to environment. Honorable Justice C. Shankaran Nair of Kerala High Court in the landmark case of Attukoya Thangal for the first time in India declared that the right to life is much more than the right to animal existence, and its attributes are manifold, as life itself, the right to sweet water, a right to free air, attributes of the right to life, for these are the basic elements which sustain life itself. Subsequently, the interpretation of the Kerala High Court was followed by the Indian Supreme Court in Subhash Kumar versus State of Bihar and others. The court observed that the right to life under Article 21 include the right of enjoyment of pollution-free water and air for full enjoyment of life. Further, in D.D. Vyas versus Ghaziabad Development Authority, the Allahabad High Court added that if anything endangers or impairs the quality of life in derogation of laws, a citizen has the right to have recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to the quality of life. Thus, individuals not only have the right to environment but also have a remedy in case of any violation. It is to be noted that this right to environment includes pollution-free water also. It is further affirmed by the Supreme Court in Virendra Gaur and others versus State of Haryana that environmental, ecological, air, water pollution, etc. should be regarded as amounting to violation of the right to environment under Article 21. This approach has been affirmed by the Indian judiciary in numerous cases. Preservation of open spaces and parks. Green parks and open spaces are said to be the lungs of the cities and urban areas. They are essential for maintaining the quality of air as well as for preserving natural beauty of the land. In fact, fresh and clean air and green trees are the gifts of nature and are vital for living a healthy life. However, the underplanned development of cities and the unplanning rather and towns is destroying the boundlessness of nature. Due to the ill-planned development, most of cities are facing the problems of heavy traffic, congestion, lack of open spaces and green parks. These are concrete jungles in the form of huge buildings and shopping malls, and there is absence of green trees and open spaces. The concrete jungle, along with vehicular pollution, contributes significantly to global warming and climate change. The Indian judiciary has noted the attitude of government and peoples and have taken bold steps to preserve open spaces and public parks in various cases. In the case of Bangalore Medical Trust versus B.S. Murappa and others, by prohibiting the action of Bangalore Development Authority from converting an open space reserved for park into a private hospital site, the court observed the public interest in the reservation and the preservation of open spaces for parks and playgrounds cannot be sacrificed by leasing or selling such sites for private persons for conservation to some other user. Any such act would be contrary to legislative intent and inconsistent with the statutory requirements. Furthermore, it would be in direct conflict with the constitutional mandate to ensure that any state action is inspired by the basic values of individual freedom and dignity, addressed to the attainment of a quality of life which makes the guaranteed rights a reality for all citizens. In Virulent Guard versus State of Haryana, Supreme Court held that government had no power to sanction lease of the land vested in the municipality for being used as open space for public use after referring Principle 1 of the Stockholm Declaration 1972, Articles 48A, 47 and 51A, G and 20 of the Indian Constitution. The court observed that the word environment is of a broad spectrum which brings within its ambit hygienic atmosphere and ecological balance. It is therefore not only the duty of the state but also a duty of every citizen to maintain hygienic environment. The state in particular has duty in that behalf and to shed its extravagant, unbridled sovereign power and to forge in its policy to maintain ecological balance and hygienic environment. Article 21 protects right to life as a fundamental right, enjoyment of life, attainment including the right to life with human dignity encompasses within its ambit the protection and preservation of environment ecological balance, free from pollution of air and water, and sanitation, without which life cannot be enjoyed. Environmental, ecological, air, water pollution, etc., should be regarded as amounting to violation of Article 21. Therefore, hygienic environment is an integral facet of right to healthy life and would be impossible to live with human dignity without a humane and healthy environment. Environmental protection, therefore, has now become a matter of grave concern for human existence. Promoting environmental protection implies maintenance of the environment as a whole, comprising the man-made and the natural environment. Therefore, there is a constitutional imperative on the state government and the municipalities not only to ensure and safeguard proper environment, but also an imperative duty to take adequate measures to promote, protect and improve both the man-made and the natural environment. 5. Right against noise pollution. Noise is derived Latin word nausea, implying unwanted sound, or sound that is loud, unpleasant, unexpected. Noise pollution can be defined as unwanted, offensive sounds that unreasonably intrude into our daily activities. It has many sources, most of which are associated with urban development, road, air and rail transport, industrial noise, neighborhood and recreational noise. Environment is an aggregate of all external conditions and influences affecting the life and development of an organism. Once it is disturbed, no better living conditions for human beings can be created. Hence, to make the enjoyment of life more meaningful, the preservation and protection of natural environment must be given priority, and the human activities causing ecological imbalance must be stopped forthwith. Considering the disastrous effect of noise pollution, the Indian judiciary has explicitly declared that noise pollution contaminates the environment and thereby affects right to life. In Rabin Mukherjee and others of the state of West Bengal, the Supreme Court held that pollution arising from use of loud horns was injurious to health and was among different causes of environmental pollution. Subsequently, in more specifically, the judiciary addressed the issue of noise pollution in Free Legal Aid Cell versus Government of NCT of Delhi and others. In this case, the Delhi High Court observed that noise is a pollutant which causes material injury to the rights of an individual. It contaminates the environment, causing nuisance and affecting the health of a person, and therefore it exceeds a reasonable limit. Offends Article 21 of the Indian Constitution. Earlier, in P. A. Jacob versus S. P. Kottayam, the court held that the right to religion cannot be a ground for right to cause unreasonable noise pollution. Thus, it can be seen that any individual can claim a right against noise pollution either as a part of a right to environment or as a part of a right to life. Conclusion: a clean and healthy environment is a prerequisite to a healthy and dignified life. In fact, most of the human rights are interrelated with the right to a clean and healthy environment. The Honorable Apex Court of India has also in numerous decisions emphasized that a healthy and wholesome environment is a fundamental right which gives meaning to right to life. Thus, a healthy environment is vital for protection and preservation of right to life, and it also includes the right to health. This is because without a proper and sound health, a human being cannot enjoy the basic right to life. The Indian judiciary, through their activist role, have developed various principles for the protection and improvement of the environment. Some of the important principles of this environment issue are sustainable development, precautionary principle, polluter pays principle, and public trust doctrine. The development of all these principles along the various dimensions of right to environment would have a positive impact on the protection of environment and its natural resources. Such an effective system of legal regulation for protection of environment is a prerequisite for the realization of the right to environment. Thank you.